together. It's amazing how the association has done so well to adapt and take care of its members. It's almost, frankly, I bet for some of you, this is probably easier than than having to trudge down to one of the offices. You're able to sit there in the convenience of your home and take classes, which maybe something the association starts to do more regularly as things get more normal for all of us. Good morning, everybody. My name is Russell Jacobs. I am a commercial and residential real estate attorney, and my office does closings all over the state of Florida with our pajama closings, where we actually send paralegals out to your client's home or office to close. That's something we've been doing for years, so we were kind of COVID ready before COVID was COVID. In any event, today we're going to be doing our class on letters of intent. So if you were here for the marketing class, you're in the wrong room, but you might want to stick around. We're going to do letters of intent for both purchases and leases, and we're going to discuss all the things that you want to make sure that you include in them, and we're going to get to that in a moment. Normally, I'm right in front of you. I'm able to see you. We're able to communicate back and forth. You're able to ask questions. I'm able to work with you on the things that you're most interested in, which makes our interaction more, well, interactive. And in this case, I'm going to be doing a lot of talking, and there's not a lot you can say. So one, I'm going to ask that everybody make sure that you mute yourself, because sometimes you're in the middle of doing something and then everybody can hear what you're saying instead of me. So please make sure that everybody is muted. And I appreciate that. And I basically try to help you do that just now, just in case you weren't. So I appreciate that. And two, I'm going to try to use the chat feature a little bit. Hopefully, many of you are starting to be more familiar with how Zoom works to some degree, and you're able to move around in it a little bit. It's a little bit harder for me trying to share the screen and move in, but I'm going to give it a shot here by chatting. So if you can go to your chat, and I'm going to ask you a series of questions now, and just type in an answer and send it on back. And what that will do is give me a little bit of feedback about you and what you're interested in and how I can help you. So we'll start with how many of you, if you've prepared a letter of intent before this class, say yes. And if you haven't, say no, and just send in a little chat just so I can get a feel for how many people have done and how many people haven't. And the next question I'm going to ask, great feedback. This is excellent. Really gives me a sense of how you're working. Next class is how many of you are, if you're 0 to 5 years in practice. Actually, you know what? We can actually do this really specifically, which is amazing. Normally, when I get into a class, and if any of you have taken a class with me, I'll ask you, I'll try to divide up the number of years you practiced into brand new, been around for a little bit, or have or been a veteran and been around forever. So, but now I get to actually ask you the number of years. So if you would now type in the number of years you've been in practice as a commercial broker.
Russ, I just put a poll up. And then I will do another one in a second. I'll create a poll right now for how many years in the business.
Oh, don't worry about it, Paul. I got it. Okay. People are rapid fire responding, and I'm reading it, and I got it. So not even necessary. Like, this is fantastic. Like, it really gives me great feedback. So as many as there's disadvantages to this platform, apparently there's some advantages, because I'm getting individual responses, which I love. It lets me see what we're doing and how we're doing it. And what I'm seeing is that there's a good deal of people that are, somebody wrote me a smiley face. What I see is that we have a good deal of people that are, newer to commercial real estate, and some veterans. So let me tell you, I can tell you that you're going to get a lot out of this class, whether you're new or a veteran, but it helps me kind of frame things. And I'll spend a few moments helping out the newer brokers so they can figure this out, and the vets are going to get hopefully some meaty information. Typically, the way I'm going to run this class is I'm going to talk a lot. I'm going to walk you through this process, take you through letters of intent, and then when I get to certain stopping points, I'm going to ask for questions, which I see are already starting to come in. But I won't be able to look at the questions and lead the class at the same time. I can usually do many things at once, but I may not be that good. So what we're going to do is we're going to try to take breaks at different spots, and then I'm going to ask questions about the stuff I just went over, and then you can ask a couple questions. I'm going to take like maybe 2 or 3 questions just to make sure we didn't lose anybody, and then much of you are going to have yearning questions you have to answer. What we'll do is at the end, I'll do a full Q&A, and then you can ask me any question you want to ask of a real estate lawyer, whether it's related to this or anything else, and we'll go through the questions and try to answer as many as we can with the time we have. So hopefully that sounds fair. You can't really nod your head, and if you are, I can't see you anyway, so it doesn't matter. And so we'll get this thing moving here. So like I said, I'm Russ Jacobs, commercial and residential real estate. Been doing this 25 years for large firms, in-house counsel, and now we're a 10-member firm that does this. If you would like a copy of my PowerPoint presentation, so you don't have to frantically write all this stuff down, not a problem. Paul just needs to have your name on an email list, and we will go ahead and email out the PowerPoint presentation later on today. So you will have a copy of it if you like. You just make sure that Paul has your email address, and then Paul, if you can send that to Carolina, we'll get that out for everybody. Let's dive kind of right into it if we can. For our newer brokers in the room, basically, you know, a lot of times in these classes, we get some resi-mercial, people who are residential and are trying to shift into commercial. So I'm going to just spend a moment for our newer agents, brokers, and people shifting in, because commercial is a totally different animal than residential. And in residential, you just have the form contract, you work with that. We teach a whole separate class on that. Some lower level commercial deals, you can use the CC5 contract, and it kind of can work similarly. And in those cases, we teach a class for that also. And if you want the CC5 class, just ask Paul, and I'm sure he'll schedule it with us. But today, when you're dealing with leases or you're dealing with more higher level purchases, the broker's first job is to find out if there's even deal terms to work. Why? Because clients are cheap. They don't want to pay for an attorney up front. They want you to do as much work as possible. They're there to make you their slaves and make you run around and jump hoops and do all the things because of that big commission you earn. So they're going to want you to do as much lifting as possible and pay their lawyer the least amount possible. And it's in fact watching that happen over and over again that I decided we needed a class in this to help you kind of get you through this when your client is too cheap to hire a lawyer to do a letter of intent. So if you have a client who's not cheap and can do a letter of intent, phenomenal. Then you can have that client's attorney prepare it. If the client doesn't have an attorney, I'm all happy to jump in and help out. Hint, hint. Shameless plug, certainly happy to take business in that direction, but really the goal of this class is to help prepare you so that you can do it if you are stuck doing it. I'd always rather have an attorney do these letters of intent because it takes away liability from you. Anytime you can get somebody else to do something and the client relies on them, that means they're not relying on you. That means that there's less liability, and that makes you, for a deal that can get done with you having less liability, is always a better deal. So in any event, that's enough about that. Ultimately, clients may be too cheap, and now you're going to have to do a letter of intent. Why? Because at the end of the day, when you get to a purchase contract on a higher level deal, you know, 3, 5, 10 million up, 20 million, etc., or you're doing a lease, there is not a form for that. We don't have forms for this. Lawyers draft these things. Okay, and lawyers charge many, many thousands of dollars to draft them. So your client doesn't necessarily want to Your client doesn't necessarily want to pay for that if there's actually no deal there. So in a lease, we want to make sure between landlord and tenant that the terms are there. And I'm going to get to those terms in a minute, so we won't go through them in nauseating detail right now. But you want to make sure the basic outline of the deal is there. Same with a purchase. You know, do you have the right purchase price? Do you have the right deposit? Do you have the right closing date? On a lease, do you have the right lease term? Do you have the right rental amount? Do you have it? Is it gross? Is it triple net? Is it double net? Et cetera, et cetera. Again, going to get into that in a moment. But the idea is that a letter of intent is something that you draft that's intended to be non-binding. I will get to that in a moment as well. But the idea is that essentially you get the deal terms together, and then once the deal terms are together and both parties are comfortable that the basics are there, then it can go to the lawyers if the lawyers aren't drafting letter of intent. And then the lawyers can go ahead and draft the contract, knowing that there's a good faith effort to get everybody connected and connect up and do things. The key thing to understand about a letter of intent is that there is no set form. The form is whatever you dream it to be, as long as you get the basics down, and as long as you make sure that it's either binding or non-binding, depending on what you want. And we'll get into the binding and non-binding in a little bit. Letters of intent are not the same either for purchases or leases for different assets, different asset classes. When I say asset class, I mean, is it a warehouse? Is it an office space? Is it an office building? Is it a hotel with a food and beverage operation? Is it a multifamily apartment, if you should be so lucky down here not to get one that's a 3 cap? So the question is, you know, which type of asset is it? And then letters of intent should be geared towards that. So if you're a specialist in a particular area, fantastic, then you're going to drive your letter of intent towards that area. If you're kind of doing everything, then you're going to want to set up letters of intent that focus on different things at different times. I've been doing this just about 25 years, and I spent a lot of time honing these skills. We're going to do this class in, you know, basically an hour and a half or so. And so I can't possibly cover every permutation of every asset that ever exists in what you include, but we're going to hit the large bulk of everything you need to include. And if you're missing something, I will be surprised. So we should be there. So that's a little bit about how this is going to work and why you need letters of intent. And at this point, we need to move into contracts a moment on purchases. Essentially, because they're prepared by attorneys, there is no such thing as standard. The more things you put in the letter of intent, the less negotiating there's going to be later. The last thing that you want to see is that you put just like 3 terms in the letter of intent, and then the lawyers spend months back and forth negotiating all the terms. That's just going to slow down your deal. And there's a saying in commercial brokerage, time kills deals. If people have time to go back and forth and they keep going back and forth, someone's going to get tired and they may get annoyed, and that's a good way for a deal to break apart. So you want to move as fast as you possibly can to get things in order while everyone's still excited and happy and they don't see changes in the market. Their eyes don't start shifting to other spaces, other places, etc. So you want to be able to move through that. And you want to have that ready. So very, very important. All right, let's jump into purchases. Typically, it is the landlord that's going to prepare it for the lease, but on the purchases, it's typically the buyer that's going to put together a letter of intent. So if you're the buyer's broker, you're probably going to be the one expected to put in a letter of intent. And there are different kinds of ways to do that. You can use a short form, basically just really, really kind of quick, or a long form. And let's kind of walk through for a purchase what you would want to see in each. So for a purchase, and these would really be purchases, I would tell you there's no rule of thumb on this. I would probably say it depends on the asset. If you're buying a multifamily building, I think you can go up to even 5 million and use the standard form of the CC5 contract, but you're going to need the attorney to prepare an addendum to the CC5 because the CC5 does not do it justice. Again, whole different class. We can get into that if you like, and have that done. Sorry, the thing shifted by accident. So ultimately, if you want that class, we can teach that. But I would say multifamily is over 5. Office buildings, I wouldn't do any more than like 2 million. Hotels, I wouldn't do anything but a standard, but a pre contract prepared by an attorney almost ever. There's just too many issues that are involved in that. Warehouses, I'm okay at between 2, 3, 4 million. These are rules of thumb, really just kind of guidelines. You really have to feel that out as much as possible. But above those numbers, for those kinds of assets, I would not do a standard contract with an addendum. I would probably shift into having the attorney write it, which means your letter of intent is going to need to be more detailed, more robust. The more detailed and robust you can make your letter of intent, the less negotiating there is later. So depending on the asset, you might use short or long form. So in the short form of the letter of intent for a purchase, the key is going to be the parties. That seems kind of obvious, but this is a chance to narrow down who is the actual owner. Is the owner an LLC? Is it in a trust? Is it some other structure? A good way to figure that out is to go to Miami-Dade My Home, look on the last warranty deed or quitclaim deed that was indicated, and use the exact same party information that appears on that deed for your seller. For your buyer, I highly recommend that as a buyer of commercial property, you always set up a separate entity structure for that particular purchase so that it doesn't commingle with your other property. We also teach a class, I feel like a broken record here, but it's true. We teach a class called the 5 Reasons Why You Shouldn't Buy a Property in Your Own Name and the 1 Reason You Should, where we get into the nauseating details of assets and how to structure them in LLCs and corporations and trusts and how they blend and when you use them and what they involve and that kind of thing. So again, if you're interested in that class, let Paul know. But ultimately, the buyer should probably set this up in a separate structure. So you're going to want to make sure that your letter of intent has assignment rights that allow your purchaser to assign the entity to, for instance, an entity owned or controlled by them. If you do that, have a little less issue with them having their individual name on the letter of intent. If this is just getting started, or you can use one of their other companies, but you definitely want to have an assignment right and make sure that that's clear. And you can tell the other side why you want that. It's for entity structuring and estate planning and asset protection, not because you're trying to flip a deal. And most people will understand that. Property description. This seems kind of obvious, but it's not. You want the full legal description in there. Usually you can do that as an exhibit. My cheat sheet way of doing this so you don't mess this up is, again, you go to Miami-Dade My Home. You look for the last warranty deed, not quitclaim deed. Do not use a legal description from a quitclaim deed, please. They're not warranted. Go back to the last warranty deed, and you can cut and paste the legal description right from Miami-Dade My Home, from the warranty deed, and you make it an exhibit to your LOI, and now you have a good base to start with. Not to mention, it gives you, Miami-Dade My Home gives you an aerial where you can see that that's the property you're talking about, and it does it include the parking lot? Does it not include the parking lot? Does it include like other areas, other properties that you didn't intend? It's kind of your first sign or indication as to what it is. And I will tell you that even as an attorney, and especially as a broker, I suggest that you walk the property. There's no substitution as a buyer's agent for being able to walk the property, be able to see what's going on there, eyeball it yourself, see what the issues are so that you can address them right up front and make sure that they're handled for your client. I'll get into more of that on leasing, but I think it's important for purchasing also. Are they including other property in there? And the answer to that is depends, right? So if they are, make sure that the other properties be included. Obviously, price is key, and that's one of the most material and important terms you can think of. So make sure, and that's probably what's going to go back and forth the most. So make sure your purchase price is in there. Deposits. How many are there going to be? Is there going to be 1, 2, 3? Are they going to happen at different stages in the deal? How much are those deposits going to be? That oftentimes makes a difference. Your due diligence or your inspection period. How long do you need to review the property? In residential, maybe that's easy. Maybe that's 7, that's 10 or 15 days. You can't really do that in commercial. In commercial, you've got a lot more due diligence to do, especially if financing is involved. Are you going to be doing an environmental phase 1? What if it comes back contaminated or with a recommendation for a phase 2 to be done? Well, you have time to do that. Very important to kind of get that in early and make sure that if there is a phase 2 that's needed, you have time and the ability to get that done. Are you changing the use? Is your client going to change the use? Is it office right now? Or is it going to go to retail? If it is, maybe you need to get more time for due diligence because you have to go to the city or county and find out what's needed to change the use. From a zoning perspective, maybe you need to hire a land use lawyer. That's going to take some time with that. So you're going to want to make sure that you include that kind of time. Maybe if it's a multifamily, so it's an apartment building, there's only a few tenants, or maybe there's not a lot of tenants. Maybe there's less due diligence that needs to get done on a cash deal like that, and maybe you could cut it down to 20 or 30 days, but that's not the norm unless you're in a complete seller's market and there's a free feeding frenzy, and maybe there's not that many tenants, and maybe there's it's not anywhere near a gas station or otherwise. So ultimately, then maybe your due diligence is shorter or longer. I rarely see anything shorter than 30 days, except in those extremely rare, interesting circumstances. We more likely see 60 days. That's very, very common. If you're doing a change in use or you need governmental approvals, I've seen due diligence as long as 180 days or even a year. Or 9 months. It just really depends on the property and what you're doing to it, what your client needs to do. Is there financing? Are you building from vacant land, and do you need to do soil compaction tests? So there's lots of different rules of thumb on that, and it really just depends on the type of commercial asset that you are working with. But you want to make sure you have enough due diligence to get that done. Sometimes you'll have sellers who will say, okay, you can have 30 or 45 days, and if you want more time, you have to buy it. So you have to put down more deposit that's non-refundable, maybe a portion's non-refundable, in order for us to take the property off the market and let you do the due diligence that you want. A lot of times that's negotiated at the toward the end of that property. So it's certainly just, again, depends on the asset and what you're doing with it, but it's really an important consideration and one you really want to talk with your client about in terms of what kind of time they need. Closing date, that's an obvious one and a big one that definitely needs to be in the letter of intent. Are you closing within so many days after due diligence? Like many times we might have one where once due diligence ends, if there's no financing, maybe we're going to close 15 days after due diligence ends, or 20 days after due diligence ends, or we have a specific closing date or a date that runs from the effective date. So it really just depends on the specifics of the deal again, but you're going to want your closing date, down. Financing considerations. Are you getting financing? I will tell you that for commercial deals, financing usually doesn't happen shorter than 90 days on conventional financing. So you're going to want to have, if you're going to have a financing contingency, you're going to want to get 75 or 90 days in there for your financing in order to make sure that you come back with an approval or a loan commitment that tells you where you stand. Very important. Is this cash? Fine. Is it cash, but you're going to get financing anyway? So do you want an appraisal contingency in there perhaps? Maybe you want an insurability contingency in there to make sure that you get insurance or that you have an appraisal. Very, very, very important stuff. Other contingencies that you might have in there. Maybe there's something specific that has to occur in the process in order for you to be able to get the deal done. Do you need to lock down another piece of property? That's obviously could be very important for you. So you want to think about what those other contingencies or other significant issues are. Again, this is where walking the property is really, really helpful. And of course, the most important thing ever on the face of this earth, and while you're taking this class, make sure that your commission is in the letter of intent. Very, very, very important. Yes, you have a commission agreement with the seller. I get that. But as an attorney, I will tell you, I personally want to make sure that Broker's commissions are in the letter of intent and then in the contract. Why? Because now I have a buyer and a seller signing off that this closing isn't happening without these brokers getting paid this amount. It's very specific, very easy, very, very, very clear. So for that, very, very important for you to include, I think, and no one should look askance at that. You're preparing the darn letter of intent. They're making you do it. The least they could do is make sure you get a commission indicated in there. So take care of yourself. Make sure the commission's in there. Absolutely not. Are you purchasing as is, okay? Or are there representations and warranties? You are not a lawyer. You did not get trained as a lawyer. You are not going to know all the representations and warranties that should be in there. So let me give you a little tidbit or help on that. What I would do on your letter of intent, because you're not a lawyer, is if you're the seller, be quiet. Don't put anything in there. You don't want to give any representations and warranties if you're the seller. You don't want any at all. So if they ask for them, cross them out. If they don't cross them out, try to cross them out anyway. If you're a buyer, you absolutely want representations and warranties. It's actually amazing to me that in a purchase, the CC5 has no representations and warranties from the seller. I have never understood why that was, but through multiple versions of the CC5, they have never had it. It's one reason why certain things in the CC5 have to change. Not this class, that's a different class, so never mind. All I'm telling you as a buyer is you want them. But you're gonna tell me, I don't know what those are, Russ. I didn't go to law school. I'm not a lawyer practicing for 25 years in real estate. What on earth do I write? And it's simple. Do something as simple as this. Just indicate that seller will give the representations and warranties that are reasonably given for other commercial properties of a similar kind. Put that down. At least get that in, okay, if you don't have an attorney helping you out. And then when the attorney sees it, first of all, they're going to realize that you know what you're doing. And two, you're going to leave the whole window open for the buyer to be able to get those in. If you can't do it, don't worry. You're a broker, not a lawyer. And if the client was too cheap not to hire a lawyer, that's what they get. You know, then they're not going to get representations and warranties because they should have hired the lawyer to write the letter of intent in the first place, but they didn't. And so they get what they get. But if you're able to do it and you're able to sneak it in, please make sure your client knows you put it in there and why that's important to do, because obviously that's going to make you look like an expert. And I am going to try to repeat this again, but I will probably not be able to say the same thing twice. It's a lot like my mother's cooking. Whether I liked her meal or I didn't like her meal, I never got the same thing twice. So I'm not sure if you're going to hit the same thing twice, but I'm going to give it a shot. What you're going to put in the letter of intent for your purchases, if you are representing the buyer, if you're representing the seller, don't put anything in. You don't want any representations and warranties. If you're the buyer, try to put in something like seller will give the representations and warranties that are customary to a similarly situated property in fill in the county. Okay, so that should be good enough to get you where you need to be. Again, you're not a lawyer, you didn't stay at a Holiday Inn Express last night, so you may not necessarily be able to do everything you can. Try to get that in. If you can, you can. If you can't, you can't. I'll do it one more time because I don't have it up on here, which now reminds me I should have it up on here. So I will try to add that later. Carolina, see if you can remember to remind me to do that for our next class. But ultimately, if you have representations and warranties, if you're the buyer, not if you're the seller, then you might say, sellers shall give representations and warranties that are customary for a similarly situated property in blah, blah county, Florida. And again, this letters of intent, everything I'm describing is the same whether you're in Palm Beach, you're in Broward, you're in Dade, you're in Collier, you're in Lee. This is Florida-based stuff. So there could be county-specific considerations, but frankly, if Miami-Dade, Broward, and Palm Beach don't have them, it's unlikely the other ones do. And again, your client should have hired a lawyer instead of you, so they get what they get, and you're perfectly fine doing it the way I'm telling you. You'll be better than 95% of everybody else on earth. So that's that. Sometimes you need, that should all be in an LOI for a purchase, no matter what you're doing. Everything I just mentioned in the short form should be there, okay? In the long form, that's kind of like the extra bonuses. It's the things you add when your deal gets a little bit more complicated and it needs a little bit more oomph, a little bit more involvement. Then you're gonna probably add more things to your letter of intent. All long form and short form mean is just the shorter form of a letter of intent and the longer form of a letter of intent where there's more stuff in it. So for the more stuff in it, the long form, other things that you might consider and you may or may not want to include is a confidentiality provision. If you're a seller and you're selling this off market, you don't want the buyer blabbing to everybody else and their agent what price you negotiated for. Just a basic idea. So you might want to indicate that the buyer and seller and the brokers agree to keep all terms of the letter of intent confidential, whether or not the deal proceeds or terminates, or the letter of intent terminates. Very, very key in some deals it doesn't matter. So I've seen that. Water rights. Are you on or near water? If you are, do you need use of that water for some reason? Is this something that's on the river? So you may have certain water rights that what you want to have. Environmental considerations. Again, coming back to phase ones, phase twos. Is this a contaminated site? Are you next door to a gas station or a laundromat? If there is, and you are down gradient of that, there's a good chance you're getting to phase two. So kind of know that up front. Deal with those issues. Phase ones take 2 to 3 weeks and are about, I don't know, between 1,500 and 3 grand, 2,500 bucks to get a phase one. Phase twos are like 10 grand and can take you, anywhere between 2 or 3 weeks and like a month. And when they're really, really busy, which is not now, like 6 weeks. So plan that into your letter of intent. Figure that out. Sometimes you want title review period. So how long do they get to review certain things? A lot of times in commercial, the due diligence period is long enough that sellers, hint, hint, that's you when you're selling, want to tie in all the contingencies, financing, title, inspections, throw everything into the due diligence period so that at the end of the due diligence period, you've got it or you don't. Okay, very, very, very key. Closing costs. Most of the time, you don't really need to get into that in the letter of intent. Sometimes you want to. Maybe you're splitting things. Maybe it's not going to go the way the county normally does it. I hate in Palm Beach that the sellers a lot of times pay for title. To me, it makes absolutely no sense. On God's green earth, it should be the buyer who takes care of it, selects the title agent, and pays for it. Palm Beach is weird, as is the rest of the whole state of Florida. Miami-Dade and Broward have that one right. Maybe you want to shift costs. Maybe you want to change things. You might do that in a letter of intent. Representations and warranties we discussed. I'm going to definitely add that clause in there. I appreciate you guys helping each other out. I'm kind of eyeballing the chat, but I can't stare at it. So I appreciate the team effort we have here. Cheryl, you're hired as an extra assistant. Documents to be executed. Are there separate documents that need to be to happen? Are there tenants in the property, and are you taking over those tenants? Really, really key. Are you going to get rent rolls? Are you going to keep the tenants? Are you going to lose the tenants? What does that look like for a purchase? Are there particular items that need to be addressed there? Perhaps. Is this vacant land, and is it going to get developed? Do you need the development rights of the seller in order to be able to move forward? How is the purchase price going to be allocated from a tax perspective? Maybe you indicate that if you're representing the seller or you're representing the buyer, you indicate that party their accountant will determine the price allocation. Just simple things like that. If you're new to this and you're not comfortable, don't add too much. Stick to the items I have in my short form for the purchase, and you'll be fine. That's more than enough that needs to be in there. Long form stuff is really the stuff we kind of get into the nitty gritty about, and so it's an opportunity. So I'm going to stop for a moment because I spent a lot of time talking, and I'm going to ask you guys for questions. I'll take 2 or 3 questions. If your question doesn't get answered, don't worry. I'm going to ask for questions at the end. But for right now, does anybody have questions about the content of the letter of intent for a purchase? I'm going to do leases next. So if you have a question, go ahead and put it into the chat for a moment, and I'll try to scan through them and read to see if we have any questions. I understand that all LOI were non-binding. That's not true. I'm going to get into that in the third phase of our discussion. So I'm going to leave that for then because I don't want to spoil all the surprises, and we're talking about this. So I will get into binding or not binding later on. And I'm sending you all my email right now, and I'm sending you, more important than my email, I'm sending you Carolina's email. So that you have it, because if you don't send it to her, I may never see it. So are LOIs mandatory? Great question. The answer is absolutely not. There's nothing mandatory. Commercial real estate is the Wild West. You can kind of do whatever you want that both parties will agree to. The issue is that they don't want to spend money on a lawyer drafting contracts unless we're kind of sure we've got the price right. So if you're on a kind of a low level deal, you're like $1 million, $2 million, $500,000 for a single tenant office building that's a standalone, you don't have to worry about the letter of intent so much. Just use the CC5 contract and send it over like an offer, and then you can bounce back and forth because it'll have all the material terms in it. You don't really need to do the LOI because the CC5 should take you about, I don't know, 15 minutes, 20 minutes, whatever it is to prepare, and it's going to be faster than trying to scramble around doing the letter of intent. But if you've got a $5 million deal for an office building or a $20 million deal for an office building, you're going to need a letter of intent because the client's typically not going to want to spend money on a lawyer drafting a 20 or 40-page contract for a deal and spending several thousands of dollars if we don't even know if we got the purchase price correct. So, so definitely you want to be able to do that. What price range is a reasonable price for an LOI on a $1 to $2 million tenant? Same for a $10 million deal. So when I will tell you that when we're doing multi-tenant properties, they're pretty standard. The purchase price almost doesn't matter. It really matters a lot about the tenants and stuff like that. We'll typically charge in the neighborhood of just under $2,000, about $1,750 for a letter of intent. Give or take. It just kind of depends. If they get more complicated, it could be a little bit more expensive. Usually not much more expensive than that. So that's a little bit helpful. We had a question before, how long are inspection periods? I can tell you that it really depends on the type of asset class. If you have a multi-family tenant property that's just an apartment building and it's not anywhere near a gas station, it's not anywhere near a dry cleaner, it's been around, the building's been standing for like 50 years, and it got its 40-year recertification already. One of those deals, it's all cash. You probably could squeeze your due diligence in like 20 days. I've seen it done in 15, but it's horrendous and you don't want to do that. So if you're the buyer side, I'd probably go with a nice even 30 just to be on the safe side, and then they can always cut you back if they need to, and that would be fine. If you're on vacant land that's getting developed into a shopping center, you're going to need months because you got to go get zoning approvals, and you certainly don't want to buy a piece of property that you think you can develop into something, and then it turns out you can't develop it into that. So you're definitely going to want to do that. Letter of intent does not need to be prepared by an attorney. It's not a requirement. Commercial brokers prepare them all the time. It's the very reason we're having this class, because you get stuck putting them together, or maybe the attorney's too slow and you don't want to lose the deal, whatever it may be. My goal today is to try and help make sure that your letters of intent got what you need to get in it, so you can keep the deal moving forward, and you'll be there. So that's definitely a question. Let's shift now, if I can, to letters of intent for leases. So if all you do is purchases and acquisitions, you can kind of listen in and take a small nap, and we'll wake you up when we get to the next segment. If you are doing leases, then this is what you've been waiting for your whole life, and it's here. So congratulations to you. And again, I promise we'll take questions from you on anything you want in our Q&A session once we're done with the presentation, which we'll wrap up and be able to allow that to happen. So we're shifting gears now to leases. So here, almost always there's a letter of intent, unless it's just a really, really small, maybe a really small space in a shopping center, and the landlords kind of take it or leave it. You're going to see letters of intent a lot more often in leasing. It's fairly common, almost the standard practice, to have an LOI first before a lease. Is it necessary? Nope. You do not need a letter of intent before. You can go right into the lease if you like. It's really just about how much you're paying the attorneys to negotiate the lease, which can be several thousands of dollars very easily for the longer leases. Not even a question. So letters of intent kind of help make sure you have the terms down, and leases can be very tricky, as you will soon see if you don't already know. So jumping right in, we have a long form and a short form here too. So I'm going to walk you through all the basics in terms of what you would need to include. So first of all, again, the parties. Seems kind of obvious, but not always. Your tenant may not be the exact tenant who's going to be there. Maybe they have an operating entity. Maybe for licensing purposes, they have an entity that's leasing, and then they have a second entity that's operating, and that needs to be included in the lease. It just depends on kind of how they structure that. You'll have to talk to your client about how they operate and how they work to decide how the parties are there. Property description is a little bit easier in leases than it is in purchases. For property description and leases, you can actually get away with a mailing address if that works. In a purchase contract for a purchase, you can't do that. You have to have the legal and the address if there is one. In a lease, you can actually just have the property address if your space that you're leasing is part of a larger space and it's a smaller area that doesn't have an identifiable address. What we often do is include the address and then have a little like graphic chart of the property where we kind of like hash mark out the shaded area that is the leased area. I would highly recommend getting someone to do some measurements at that point, because if there's a wall there or not, you kind of want to make sure that the space is defined and that we're all clear on the square footage. One kind of key thing that happens with leases is that the landlord tells you what the square footage is, and then the tenant kind of takes it at their word, which to me is nuts. I would get an appraiser, certainly has a measuring tape. Get a tape measure if you have to. Check websites, but really you want to make sure that the usable space you have for your lease matches the square footage that the landlord is telling you have, because otherwise you are paying rent per square foot on a basis that's not the square feet you got. And of course, if you're the tenant and it turns out the square feet on the lease is less than you actually have, don't say anything. The chances are that that's happening are pretty much slim and zero. So that's probably not going to happen to you. So you really want to make sure that you measure the space before you sign the lease. That's kind of the thing with leases, is you don't get the due diligence. All you do is you get the lease, you get to see the space like once or twice, and then they expect you to sign a lease that's immediately binding at the moment you sign the lease. So typically you want to do your due diligence before you sign the lease. So if you're a landlord, obviously that doesn't impact you. If you're representing a tenant, you want to make sure you not only see the space, but you have a contractor go in and make sure that all the utilities are where they need to be. Everything is where it needs to be for your contractor to build out the space. And that's if you're building out the space, so you have that. But the tenant ultimately is responsible for measuring the space out. The tenant is ultimately responsible for making sure they can use the space for what they want. The tenant is ultimately responsible for making sure that the property complies with the Americans with Disabilities Act. tenant is usually responsible for making sure that the contractor that they engage can build a space out for the way they want to. And all that needs to be done before you sign the lease. So a letter of intent is a great opportunity for you to be able to get the terms down. And while you're negotiating that, make sure you're having someone go to the space, measure it, check out these costs while you're engaging the landlord on the letter of intent to know that you're trying to secure the property. And then those details may go into your letter of intent to make sure that they are addressed in the lease and that your tenant is getting what they want. If you're a landlord, it is race to the finish line. Don't say anything. That's what needs to happen. Tenant needs to pay, and that's it. So that was a little bit about that. Now, there are three main dates in a lease that are important to understand when you are drafting a letter of intent, or you're reviewing a lease, or you're even dealing with a lease. That's the effective date of the lease, when the lease itself is binding, when possession starts, called the commencement date. So when do you get the keys to the property to be able to start doing your work? That may be after the landlord does certain work, for instance, or it may be immediately when you execute the lease, but that is called the commencement date. So you have an effective date of the lease when it's signed and binding on everybody. You have a commencement date for when you actually get the keys and can begin to possess the lease as a tenant, to begin to make improvements, move in, start business, do what you need to do. And then there's the rent commencement date. So the rent commencement date is when rent starts to get paid to the landlord. And that may not be the same as the commencement date. So you can have a lease signed now. The landlord could do a bunch of work on the property that may take 3 months to do. Then the tenant has to do work to get their space set up, and that could take a year or 2 months or 3 weeks or no time. And then the rent may start right after the tenant is operating, or the tenant finishes their improvements, or exactly 2 months after the tenant gets the keys, or immediately when the tenant gets the keys. All of that is fully negotiable, completely negotiable in every deal. It just depends. And I will tell you, as a hint for tenant brokers, the easiest thing for a landlord to do is to give you a rental abatement. So maybe your price per square foot is higher than you'd like, but they're not willing to budge. Maybe they're not willing to budge on other terms about when you start and so on. What they might budge on, certainly what institutional landlords are more willing to give, especially in this market, is what we refer to as a rent abatement, meaning that your rent doesn't start for some period after your lease starts. And maybe, like, for example, a restaurant, kind of a bad example right now, especially starting tomorrow when restaurants are closed again. But if you're a restaurant, a lot of times you need a big lead up time to get your lease in place. And then the rent needs to start much later in order to get you ramped up and get revenue flowing. So you really want to think about each tenant and what they need, and have kind of a conversation in terms of figuring that out, to figure out when your rent commencement is going to start, or when you're going to suggest it starts, I guess, is the fair point of a letter of intent. And obviously you negotiate down, not up. So you want to put your best foot forward in your original letter of intent as a tenant broker. And then obviously as a seller, you're going to strike that out and shorten it and do what you need to do in order to get a deal. But since tenants are going to be harder to find right now, maybe that's not what you do for the moment. I guess you need to see. Are there any rent credits? So, or tenant improvement work. For example, is the space not fully ready for a tenant, and does a tenant need to do this? Needs to take care and putting work together, what we refer to as TI, or tenant improvement work. Is the landlord going to pay for some of that? That is very common. So you may outfit your restaurant, for instance, and may spend $1 million doing so. And then maybe the landlord, because you're fitting out the space, gives you back maybe $30 a square foot or $50 a square foot, or pays for half of your TI or otherwise. And a lot of times the landlord will do that after you finish completing the space and you get a CO and you pay your first month's rent. then the landlord may go back and issue you a credit for your tenant improvement work, to give you an incentive to get it done and obviously make the space more valuable for the landlord. Some landlords won't offer TI at all. So you have to figure that out. If you're a tenant, obviously you're going to request it. And if you're a landlord, you're going to strike it. And you kind of see where you kind of get to in the middle to kind of make a deal work. Term. Term is really, 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 really key. Term is very, very important to the process. Are you going to have a long term to start with? Are you doing 5 years, 10 years up front? And then are you going to have renewal terms where you can renew the lease, every 3 years? Or are you going to have a shorter term? If you have a brand new tenant who's just starting a new business and they've never been in business before, may I highly recommend that you do a smaller lease term upfront with renewal periods. So I might do 3 years renewable with 3 more 3-year renewals. So essentially I'm getting 12 years of leasing, but I'm doing it in 3-year choppy blocks. Why would I do that? Well, if I have a brand new tenant who's never been in business before, one of the problems is that if they fail, the landlord can go after them for all of the rent that's due for the term. So maybe I don't want to make that term too long because that is a lot of money for them to go back on. So maybe I want to make that term shorter. So if they mess up or something happens, they're not as responsible for things. There, I might also negotiate an early termination provision where, for instance, they get to pay 3 or 4 months rent and get out early if that happens. So some landlords are willing to do that if you give them a substantial amount of months of rent, and that can save a lot of headache and lawsuits later on. But generally speaking, 3 years would be kind of on the short side. 10 years would be kind of on the long side. But again, it depends on the asset. Are we talking about a retail space? Are we talking about an office condo or an office building? Are we talking about a warehouse space? It kind of depends on the asset, but generally speaking, 3 is on the shorter side, 10 is on the longer side. I have plenty of leases that are 20-year leases. So it really just kind of depends on kind of where you're at. Let's see, so term is important. Renewals I just mentioned, so that's important. The most important thing is what's the rent? Rent is typically based on square footage. Typically, that's calculated on an annual basis. So you take the square footage of the space, you figure out the price per square foot, and you get your annual rent, and then you divide that by 12 to figure out what your monthly rent is going to be for the space. Does that include a gross lease, meaning that number that you're given is the entire number plus sales tax? Or are you in a triple net scenario where you pay a base rent plus you pay for the operating expenses of the shopping center, for instance, or office building, along with taxes and insurance? So operating expenses, taxes, insurance are what we refer to as triple net. So there, the tenant is paying for each thing separately, and the landlord at that point has no expenses other than the tenants pay for everything. So that works, for instance, in a office building. We see that a lot, and sometimes you'll see a base year where, for instance, the tenant only pays for increases after the year they move in, and the landlord pays for the base period, but the tenant pays for increases. So there's all sorts of different ways to do that, more ways than I can even describe for you today. But the key is to know whether or not it's going to be a gross lease, meaning everything's included in the rent plus sales tax and that's it, or you have a single, double, or triple net lease where they're paying for taxes, insurance, and operating expenses. And if they're paying operating expenses, which operating expenses would those be? Very, very key. Another one that is very important is a rate of increase, okay? Rate of increase means how much is the rent changing from year over year. So you could do either a fixed number. My favorite number for both landlords and tenants is 3% per year. Seems to be fair for both sides, in my opinion. Sometimes tenants can get away with 2 in this kind of market, and some landlords can get away with 5 in other markets. It just depends on what's going on. Or you can do what we do a cost of living adjustment, or COLA, COLA, or CPI, Consumer Price Index, where you look at the Department of Labor statistics every single year, figure out what the inflation rate is, and that's your rate of increase. That's a lot more complicated to include, but you can do that. And then basically rent only increases when inflation increases and doesn't increase when it doesn't, which is also fair for everybody. So that really just kind of depends on kind of where you're at. Operating expenses we talked about, what is going to be included, what is not going to be included. Is it going to include management fees? Is it going to include outside areas that maybe your tenant doesn't use? So you want to really look carefully at what those operating expenses do and don't include, and whether it's fair to include them or not to include them. Proportionate share essentially is the idea that when you are part of a larger shopping center or office park or warehouse, your percentage area of your space is in proportion to the rest of the space. And that's the percentage that you pay for the operating expenses, taxes, and insurance. And the idea is that if everybody does that, the landlord's at 100% and everything's included. What you should know, especially in a retail space, is certain anchor tenants, the big groceries and things like that, don't pay their proportionate share many, many times. And so you're paying, but they're not. So you want to make sure that that proportionate share, again, that square footage is really important. And you want to make sure that that square footage matches up with the proportionate share of the entire square footage of the entire property. The square footage of the entire property is a little bit easier to find because that is on Miami-Dade My Home. So you're able to at least get the square footage of the entire shopping center, warehouse, or office building. And then you need to figure out whether your client's space, if you're a tenant, matches up to the proportionate share you're getting so that you can make sure that that's accurate. Again, your responsibility to do before the lease starts. Security deposit, really big conversation. Many times it's 1 month, sometimes it's 2 months. Are they asking for a guarantee? Right? If you're a landlord, you darn bet that you're asking for a personal guarantee of all the principals of any of the businesses that are involved. As a landlord, you would never want anything but a personal guarantee, especially in South Florida, for reasons none of us need to mention, but are all aware of. And so as a tenant, you don't want a guarantee because that is uncomfortable and problematic. What if you make a mistake? What if there's a problem? Then you're stuck with this trailing you for the rest of your life and they go after you for all the rent that's due. So maybe you can negotiate for 2 or 3 months of a security deposit and no guarantee. Or maybe you can get what we refer to as a vanishing guarantee, where you're able to have a guarantee for the first 2 years or first year. And then as long as you make consistent, regular monthly payments, month in, month out, on time, every time, that they realize that over time, then your guarantee should start fading out. And then maybe by year 2 or year 3, the guarantee has been removed because you're such a good payer and you're such a good tenant, and you increase your security deposit to a number. Again, all negotiable. There is no set way of doing this. Everything is between the parties in terms of what they can negotiate. So this is really where you can do a lot of good for your client on both sides, getting your client protected in the best way possible. So definitely that's out there, and that should be in the letter of intent to know where you kind of stand before the lawyers get their meat hooks on this deal and change everything around. Okay, those are your short form letters of intent. Every letter of intent probably should have those things in it for a lease. I like a little bit more detail in my letters of intent, but that's the only reason that we have these in here. Maybe you are uncomfortable, maybe you're not, but I want you to consider these. And again, there is no substitution for you walking the property. Take a tour of it. Look up, look around you, look to the sides. What's going on at this property? How is the air conditioning run? Is it run centrally, or does your client have an individual air conditioning space? How is that dealt with? How does the landlord deal with that? In an office building, do they have HVAC hours? Meaning like after 6 p.m. and on weekends they shut the AC off? Is your client going to be sweltering hot in August? Do they need to pay extra for that? What happens there? Definitely want to know about that. Are all the utilities at the space? Does anything need to be brought to the space? Are there combined meters? Do they share an FP&L meter with the tenant next door? How is that going to be dealt with? So you want to take a look at those things carefully. Walking the property, signage. Is there signs on the property? Can you put a sign on the property? Where would the sign go? Do you want to negotiate that now while you have the landlord's attention and make sure that you get signage rights to certain areas? Absolutely want to make sure you do that. So that's really important to be in there. Real estate taxes and insurance. Who's paying them? Insurance. If the landlord's paying for the property, what about the interior contents? You're probably going to have to get insurance. How much is that going to cost you? Is it going to cover you for everything? So you want to make sure that you're covered for there. If you're a landlord, make sure you get sales tax in there. It's a silly thing to say, but if you don't put it in there, then the tenant can argue you've got gross lease and the sales tax is included. So make sure that the sales tax is indicated to be separate if you're the landlord. If you're the tenant, try to get away with making sure that it's a gross lease with sales tax included, if you can, including any and all taxes, no matter their source. Really, really helpful stuff. You may end up saving your client 7.5%. And if you do, tell your client you just did that. You don't get any points if you don't educate your client on how good you are. So please make sure your client knows what you're including, why, when you're doing it, when you're not doing it. Guarantees we discussed, signage we discussed, services related to the building. Are there other things that the building is providing for you? For instance, is there security there? Do you want to make sure that there's security there all the time? Is there, if you're a restaurant, do they take care of the grease trap cleaning? Do they have trash at the site? How is that handled? Do you have to get your own trash container and rent that? Or is that included in the lease with the property? Where is it located in connection with your space? Is it easy to get to? Is it not easy to get to? Parking is a big one for me. Where is the parking? Is there enough parking for your team? Are they going to have to park somewhere else? In an office space, for instance. In a warehouse, are there bays where you can do that? These are questions. If it's a shopping center and you have people coming in and out all the time, do you need a couple of reserved spaces right in front of your store that are reserved exclusively for you? If you're in an office building, do you have the right to tow people from your space? Or are you relying on the landlord to tow and then they never do it and then people park in your space and now the exclusive right you had is gone. So, you want to look around, keep your eyes open, check for these things, talk to your clients, make sure that you understand what you're doing on there. Do you have use of the common areas? Are there common areas you want to use? Do you need them? If you're a restaurant or a space and you need an outdoor area, is the outdoor area included or not including? Is it covered or not covered? Are there citywide restrictions on that? They're going to impinge on your ability to do that. Do you need a consultation before you sign the lease to get that? Repair responsibilities and maintenance. Typically, the interior of the space and things that service only that unit are the tenant's responsibility. Okay? Maybe they're the tenant's responsibility, maybe they're not. Who is taking care of the maintaining of the interior? Who is responsible for maintaining the exterior of the property? Are you responsible for painting your own space on the outside and sweeping the curbs? Or is that the landlord's job? Really, really, really key. Is there adequate lighting? If not, does that need to be added? Do you need a landlord to add that before you start, etc.? One of my personal favorites for tenants is their exclusivity. What does that mean? If you're a restaurant, or I don't know why I keep picking on restaurants, I probably because I have a bunch of clients for restaurants, but exclusivity. If you're serving a certain type of food, don't you want to make sure that nobody else in the shopping center is ever allowed to serve that kind of food? I've seen landlords do really stupid things where they have one tenant on one side of the property and then they have a tenant on the other side of the property doing the same thing. I don't know why a landlord would want to do that. Maybe they're desperate, but competing in the same shopping center is a really bad idea. So you want to know as a tenant maybe that in the future, the landlord's not going to lease out the property to somebody who does the same types of things that you do. It seems reasonable, but it's something you've got to include. If you're a landlord, maybe a broker, you want to know what other exclusivity provisions have already been given to tenants so you can make sure that this tenant is not running afoul of those exclusivity provisions. So certainly something you want to mention to the landlord or the landlord's attorney. And then maybe notice and notice cure periods. I love those. I don't like technical defaults. So I like the ability to give notice that there's a problem and then have a chance for instance, if I'm a tenant, to be able to fix the problem before you get defaulted and lose all of your investment. That's kind of really in the weeds. So I don't know that you would necessarily add it. I probably would, or no, I definitely would. But I don't know that you need to add that, but it's just a thought. Rules and regulations. If you are in an office building that has office medical condos, for instance, there's a lot of rules and regulations about what you do and how you do it. You need to make sure that your tenant is familiar with those. If you're the landlord, maybe you want to set out rules. For instance, in a warehouse, making sure that people use their bays correctly, they back in properly, they have the proper signage up, etc. Maybe you want them making sure they empty trash so they don't leave debris in the common areas, and you want to make that violations of your lease. So you may want rules and regulations if you're a landlord. If you're a tenant, you want to find out if there are rules and regulations from the larger body of property or whatever it is, to make sure that you can comply with those before you sign the lease. You know what those are, and if they change, you have the right to get out if they end up hurting your business. So very, very, very key stuff. So that is as much as I can provide for you on the meat and potatoes of leasing. I'd like to now take a moment to let you ask questions, maybe 2 or 3 or 4 questions about letters of intent for leasing. If you were only handling purchases, now is the time to wake up and get ready for the next segment, so you can rub your eyes, get a glass of water, and be ready for the next segment while we take 2 or 3 questions on leasing. So I see I was corrected on the sales tax percentage. It's different in every county, so you need to watch out for that in some instances. We do a blend, annual increases based on CPI with a minimum percentage. You absolutely can do that. So you say it's the rent's going to increase is going to be based on CPI, Consumer Price Index. However, it shall never be an increase of less than 3%. So now you're, as a landlord, you're getting your 3% bump, but if inflation goes skyrocketing one year and it's at 5%, you get the benefit. Obviously, as a tenant, that's awful. And you don't want that. So you might want to negotiate for a fixed price or just stick with CPI. Good luck trying to get that. What is the name of the contract I need to close on a lease? There is no contract for leasing. There's a contract for purchasing, which is the standard form CC5, which is not really good for larger deals. It's better for smaller deals. But on leasing, there is no form. There's no form at all. It's why we're having this class. Really, an attorney is going to need to draft that lease. You can't. You really can't draft that lease. An attorney's going to have to do it. But this is how you do the landlord. This is how you do the letter of intent in order to give them something to work with. Let's see. 3 years I answered would be short. Does abatement include a few months free? It can. Abatement is really what you make of it. So you can have 1 month free, 5 months free. The rent can start a year from now. You kind of can go kind of any way you want it. So other questions on leasing? I'm looking for questions on leasing. I don't know why my chat just went all the way to the top, so now I have to bring it all the way to the bottom. So bear with me just a moment. There's a lot of stuff going on in the chat, that I can tell you. Wow, it's kind of got me stuck. So I'm gonna move this down. Bear with me a moment, please. Okay. Nope. For a sublease, do you recommend to do an LOI, or sublease tenant needs to assume existing terms and conditions? Okay. If you are a tenant, subleases are okay, but assignment of leases can be a little bit dangerous. Most landlords have leasing provisions that simply indicate that the tenant, even if they sublease, even if they assign, is still fully responsible for the rent. So you're renting it out to somebody else, hoping they pay, and if they don't, you end up getting stuck anyway. And if they destroy the place, it's your security deposit that they lose. So you really, really, really want to be careful for that. But yes, I'd highly recommend an LOI on a subtenant lease. where you can at least get to the terms and conditions that are going to be there. You obviously can attach a copy of the lease and say it's going to include all of these leasing conditions, and then you may have some additional considerations of your own, like notifying you if there's a problem, so you can repair it, make sure they repair it. Additional insurance you probably want them to get that covers specifically your tenant, which would be really important. So ultimately, very, very key to probably add some of those provisions. Uh, Someone's asking about the sales tax. So I can't, it's different in every county. So I can probably get that for you and email that to you later if you like. Um, Question, if we have to bear an LOI, I need your office help in doing so. Is there a charge for that? For the letter of intent, yes, there is a charge for that because reviewing these takes painstaking amounts of time, and putting these together is a large pain in my side. Letters of intent typically are about $17.50 depending on their complexity. As I'm not uber complex, like crazy complex, that's pretty much what your client can expect to pay for a letter of intent. Leases, reviewing leases depends on the size of the lease. If it's a 5-page lease, that's obviously a hell of a lot cheaper and quicker than a 50-page lease or 40-page lease, which you see from institutional landlords, and that can be several $1,000s to review. It just really just depends. Typically, what you would do is send me a copy or Carolina a copy of the lease and have me take a look at it, and then I would tell you, okay, this is what it's going to take to do it, and this is what I would charge for it. If you're doing a purchase, we typically, if we haven't worked together, we'll charge for the letter of intent on a larger purchase. The client should be paying for that, frankly. When we have agents who work with us all the time and send us deal after deal, and their clients just being super cheap, we have been known to assist agents and just kind of help them out because we want you to succeed. When the purchase price of a hotel property is subject to the review of financial statements during the due diligence period, how do you draft this into the LOI? Really, really, really simply, in your due diligence period section of your LOI, or what we refer to as seller deliveries, you'll outline an entire list of things that the seller has to provide, and I usually do it within 5 days of the effective date of the purchase contract. So within 5 days of the contract, the seller has to give you a rent roll for all tenants. If it's a hotel property, I want to see all your daily guest lists for the last 3 months. I want to see bank statements for the last 12 months so I can see track your income and your expenses over the course of time. I want to see your P&L. I want to see your balance sheet. I want to see your food and beverage operation. I need to see all your employees. I need to know what issues or things are lurking there. So we're going to want all that in seller deliveries, and those should happen within the first few days once the purchase contract is signed. And I like to sneak in a little provision in there that extends my due diligence 1 day for every day they don't deliver me the stuff. So if I'm a buyer's attorney in that instance, I'm going to ask them, if you don't give it to me within 5 days, and then if I had a due diligence of 30 days, after day 6, day 7, I'm getting day 31, 32, 33 on my due diligence, so I'm not losing time if you're slow. Really, really kind of key. Any other questions on leasing before I delve into our last topic, and then we'll do Q&A. Okay, I don't see that, so we will move on. Okay, to bind or not to bind? That is the question. So some of you asked whether or not things were binding or not binding. And so the answer is that if you don't put in information into an LOI properly, it actually can become binding as a contract between the two parties, believe it or not. Contracts become binding on any contract at all in the state of Florida when one side gives all the material terms of an offer and the other side accepts those terms, and there's some consideration that's paid for that. So if you have an LOI that goes back and forth, and maybe there was some due diligence that was done or otherwise, a landlord or tenant could try to enforce that letter of intent on that purchase. What are material terms? For a purchase, that's the purchase price, the identity of the property, who the buyer and the seller are, and how long your due diligence is, and whether or not you have deposits. You get all that down. If you don't indicate that that LOI is not binding, that LOI becomes binding. It's a contract. It's a really lousy purchase contract, but it's a purchase contract, which doesn't do either side much good. So the question for you starting up front is whether or not you want this LOI to be binding. And I would tell you, as either a buyer or a seller, as a landlord or a tenant, pretty much 95% of the time, you don't want this thing to be binding on you. This is supposed to be an outline or a map of the terms. That's it. So if it's going to be binding, you want to stay away from that. So you're going to label it at the top, non-binding letter of intent. You are going to use words with language that's non-binding. You're going to say something like, this letter is intended only as an expression of the party's intent and is subject to entering into an agreement. It's not going to be binding on either of the parties. If you look on the PowerPoint, I have that language there. That is a really, really extensive set of language. You don't have to include all of that to get your point across. That's the really heavy lifting type stuff. You could probably use the first sentence or the last one, and you could probably get away with it so that you're able to deal with it. And that might help you out tremendously. But you want to make sure it's not binding, generally speaking, because otherwise you're going to get stuck in a deal you don't want and a deal that's difficult to have. Just because you don't include language that's non-binding doesn't mean that it will be. So if you actually do want a binding, let's say you're in a seller's market for purchases, something we haven't seen in a little while, hope to see again at some point soon. Well, let's say you're in a feeding frenzy and the buyer wants to try to lock the seller down and prevent them from going anywhere. Maybe the buyer is pretty confident of their terms, so they want to make it binding, and maybe the seller won't notice and they can lock them down into an agreement. And then this way, if the purchase contract fails, the buyer still has them locked down to the basics of price and closing. You'd only really want to do that if you're like a cash buyer, ready to go. You almost need no due diligence at all. The price is insane and you want the property real bad. So again, like 5% of the time at most. And that's a conversation you want to have with your client in writing. If you're going to do this for instance, as a broker for a purchaser, to make sure that it's clear that that's what they want before you do that. Otherwise, you're going to make it non-binding using the language I have on the screen. So you're going to use shorter language, and you're going to be able to, this is the shorter language I had for a letter of intent. So you can use this one for that part to make it non-binding. This letter of intent shall not be binding. Terms may agree upon pursuant only to a mutually acceptable purchase agreement executed by both parties as they may determine in their sole discretion. So you can use these two sentences. They're perfect for making you non-binding. You include this and it doesn't matter what else is in there. This is going to cover you, so you should be all right with that. If you are going to make it binding, you want to say so, and you want to say it, make sure it's clear. So you might say binding letter of intent, for instance, and you're going to want to include in your signature block something like I have on this page. The following constitutes the primary material terms of an agreement between the parties. They may choose to sign a contract. However, the part of their signature, they intend that this agreement bind the parties to its terms and no further agreement will be necessary. That's pretty much locking it down. There's kind of no getting out of that one. So if you're going to be binding, do it intentionally. If you want to make sure you're not binding, do it intentionally. Whatever you do, don't do it by accident. Doing things by accident is how you get sued and how you lose lawsuits. So let's not do that. Let's be very, very clear about what we're doing. Let's be very purposeful about what we're doing. So again, non-binding one way, binding the other. And really, I wouldn't recommend binding unless you got the steal deal of the century. Your buyer is basically willing to buy it sight unseen and ready to go again. So you got the non-binding and you got the binding. So you're going to be able to work with both. Oh, somebody wants me to show the non-binding and not do this really fast. See, I'm just kidding with you. This is the non-binding letter of intent. Again, you don't have to copy this down. I'm going to send you this PowerPoint All you need to do is make sure that Paul has your email address when you registered for the property, and then Carolina's going to send this out or should send this out. Sometimes Paul likes to do it himself, which I don't recommend. Really, Carolina can do this, I promise. And we'll be happy to send this out for you so that you have it. But that's the non-binding letter of intent. And then this is the binding letter of intent in terms of how you do that. Some of you may ask what the format looks like. Formats can come in either a table or a letter format. I like the letter format, which is on the left side of your screen. Basically, you imagine you're writing a business letter to the other side, addressing it to them regarding a particular property. And then on the left side, you just have the categories we're talking about. So if it's a tenant, if it's a lease, you're going to put landlord, tenant, premises, HVAC, parking, term, commencement date, all the things in underline. And then on the other side, write in like plain English, one sentence, 3 words, not too crazy, doesn't have to be formal, exactly what it is. So rent, put the number, term, 3 years, whatever you want to do, just make it nice and simple, make it work. Putting that together. Same on a purchase. Buyer, seller, purchase price, due diligence period, deposits, additional terms. Just take my meat, add them there on the left side, put the language in the middle side, and you're fine, and get it signed and out the door with your binding and non-binding language. I have not included a full format on purpose. I don't want you cutting and pasting the wrong thing from one of my deals, and then it turns out that shouldn't have belonged there, and then you get in trouble, and I don't want that to happen. So I'm including the way in which it's styled, I'm including the topics, but I promise you it's no more complicated than that. A letter addressed to the other side, and then just your bullet points on the left-hand side of what the topic is going to include, and then like a couple words, 1 word, a couple of sentences, nothing crazy, in plain English, you're good to go. And then get your binding, non-binding language at the bottom, signed, sealed, delivered, thank you very much. That's a letter of intent. It's all you have to do. I promise you it's not more complicated than that. Once you do 1 or 2 and you get the hang of it, you're going to keep this as a template going forward. Just remember, don't use the same letter of intent for different assets. If you have a warehouse, whether you're leasing it or buying it, it's a totally different deal than an office park, which is a totally different deal than a multifamily tenant building, which is a totally different deal than a hotel. So you really want to have that kind of down. I really hope you got something out of my presentation today, and it helped make you a stronger realtor. There's 43,000 brokers and realtors out there doing what you do. I think that the best way you make yourself stand out is when you educate your clients. So hopefully I've given you some education today that helps make you better. If you feel like you didn't get value out of this class, please let me know personally, and I will make sure that you do. And what I'd like to do now, for those of you willing to stay, what time is it? We're at 11:30. So I've been talking for an hour and a half straight. So I'm definitely going to take a drink of water in a moment. But what I'd like to do now, if I can, is open it up to questions, and any questions that I can answer for you, I am happy to do. Whoops, I messed that up. I am happy to do. And so you can go ahead and put in your chat questions. You can also feel free to, once you do the chat, maybe we'll unmute and we can have a conversation, but I think it's going to be easier with the number of people in the class. Just go ahead and send me a question. It could be about this or anything related to real estate, and I'll be happy to answer questions you have. I find the Q&A is highly valuable, and you learn a lot from it. So if you can, go ahead and send me some questions so I have a chance to do that, and hopefully we'll be able to get you some information. So any questions at all? Or was I that boring that all of you fell asleep and you have absolutely no questions for me? I mean, free lawyer, folks, come on. Give me something.
Can I ask you a question?
Yeah.
Good morning. Thank you so much for your insider information. Now, in a basic purchase of commercial property, if you put on the header that both parties agrees that the following terms are non-binding and just represent the general intentions of the parties on regards to the deal, will you be covered, or will the clients be covered on regards to asking the other party, or the other party requesting that this is a binding letter? Will that be enough if you put that on the header, if you introduce that language or wording?
Great question. Absolutely fantastic question. I guess the answer for me is I'm not comfortable with just saying on the top, non-binding letter of intent or binding letter of intent. Okay. Could that work? It could work, but you may find out whether it works or not after you're finished with a 2-year trial in a courtroom, which, right. Generally, I have a whole team that goes to court, but in real estate deals, I generally prefer that the deal actually goes through. Instead of breaking apart. I mean, I think we all do in this call, in the Zoom meeting. So I would add the language I've given you to the bottom of every letter of intent and be purposeful about it. Is it a binding or is it not binding? Be very, very clear.
Thank you.
I see questions for consultations. Yes, the best way to reach me is through the office, which I think I have up on the screen. You can get a time from Carolina or Bianca, who's my receptionist, and they should be able to help you. And I'm more than happy to help you. Realtors and brokers are the lifeblood of my practice. It's the way we survive and do work by referrals from you. So I'm not a big person for plugging my business. I think you come to me and you find how much you love me, and then you never want to go anywhere else. But if you need some help, I'm here to help you. That's really what I love doing most. So. By all means, if you need something in particular, if it's a very fact-specific case, let's not do that in front of everybody here. Feel free to give a call. I may not be able to reach you quite today, but I will try to if I can. Question, once you agree on the LOI, does the buyer or seller prepare the contract? Really, that's a case-by-case, but most of the time, the buyer in a purchase prepares the contract, and in a lease, the landlord prepares the lease. Does that always have to be the case? Absolutely not. You can do it any way you want if the other side agrees, but that's often how it comes. And I will tell you this, whoever gets to draft that purchase contract wins, because when the drafting, so much nuance and detail goes on, and a lot of time it gets negotiated from that point forward, not backwards. So you really get an advantage when your client is the one that's drafting the purchase contract. So very, 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 very key. If there is no personal guarantee in a commercial lease and a tenant defaults, then the landlord may only sue the tenant as a business. Nothing further. The answer is absolutely, that is the case. That is why, as a tenant, you do not like personal guarantees. Because if there is no personal guarantee and something goes wrong, they got your security deposit, they can sue the entity, but if you shut the entity down or file bankruptcy or whatever, you're personally free to start up a new company and move on with your life and not be plagued by this, because judgments, people, last 20 years. That's right. You heard me. A judgment in court lasts 20 years and becomes an automatic lien on every single piece of property you own in the same name. It is why I do a class called the 5 Reasons Why You Should Never Own Property in Your Own Name and the 1 Reason You Should. And it's to prevent that from happening to you, because you get a judgment against you on some other deal you were not even thinking about, and now some investment property that you bought in your own name has a judgment lien against it, and you can't do anything with that property until that judgment lien is satisfied. So please make sure that you're very careful and that you're involved and you're doing that. How much of a deposit could accompany a non-binding LOI? You don't really need a deposit with the LOI. Typically with an LOI, it just goes back and forth with no money in. Sometimes, and if you're the buyer or the tenant, you're not going to put any money down. If you're the landlord or the seller, you might ask them to put in a good faith deposit, which will be your initial deposit, a few $1,000s or whatever it is, and that would help you out. But typically in LOI, you won't see any money come yet. You wait until the contract's signed and then there's money. Typically would be the case. Yes, I do residential closings. We have a residential team and a commercial team. So we do both, and pajama closings are for everybody. We send our paralegals out for both commercial and residential at no charge to anyone. It's a service that we do because nobody likes sitting in an office on a closing. Everybody would rather just get about their day. So we do that. But if you do come to our office for a closing, we're happy to have you. And we have beautiful warm chocolate chip cookies and Pellegrino, although I can't always tell you that the chocolate chip cookies are warm. Sometimes they're not warm. Thank you for that. I got a nice compliment, so a couple of them. So thank you for that. It's always nice to have the feedback because we're not in the same room, and I miss seeing you guys in person where we can have a lively two-way discussion. So I appreciate that, and thank you so much for the nice compliments. It's appreciated. If you want any of the classes I mentioned, that's the CC5 commercial contract class. I also do a residential contract class. I do the 5 reasons class, which is entity structuring. So if you want any of those kinds of classes, I have like a million other classes, foreign buyers, foreign sellers. I have all sorts of classes. You can ask Paul, and he'll be happy to arrange one for you. That's how this class happened, because I was in another class. I mentioned this class, and then everybody said they wanted this class, and now we had a class. So it's that simple, and we can get that done. And if you have a broker has more than 15 agents working for them, I'm willing to do private classes as well if you can't make the time for the class that Paul sets up, although frankly it's Zoom, so how can you not? You gotta love the association and what they do. So if there are, I'll take one more question if anybody has it before we close out our session today. So let's just see if we have any other questions that I may have missed. If I missed your question and you put it a while back, then please just retype it. I'm checking, scrolling now, but I'm not seeing it. But that could just be because I'm getting old and blind. Here we go. I have a client financing a home. Okay, so this is a resi. Within 15 years, I'd like to place her son on the deed. Can that be included in the warranty? It will be a quitclaim deed. There's a whole class I teach on contracts, which talks about deeds. You never do a quitclaim deed unless you absolutely have to. This is a lesson for all of you to listen to. Okay, quitclaim deeds mean that you're saying, I am not saying I have an interest in the property. I'm not saying I don't. I'm not telling you title's good. I'm not telling you it's good. I'm not telling you it's bad. All I'm saying is if I have any interest, it's yours. Okay? There was a guy in the 1980s called Sonson who used to do deeds for Biscayne Bay. People would pay him $10,000 to do a deed for a portion of Biscayne Bay, and he'd give them a quitclaim deed, which was absolutely true. If Sonson owned any portion of Biscayne Bay, he's not saying he did, then for $10,000, whatever he owned was theirs. And guess what he owned? Zero. What it does is it breaks the chain of warranties in your title and makes you unable to use your title insurance as a proper defense. You do not want to do that. You want a warranty deed so that the chain of title continues all the way down like it's supposed to, and it doesn't get broken and stop with you. So I would definitely suggest warranty deeds. And if you have financing, you may or may not have to pay documentary stamp taxes for the state of Florida on that deed, depending on what you're doing and how you're doing it. There's a whole process to that. I'm more than happy to assist if you want to do that. And with that, I want to say thank you to all of you for being in my class. I hope you got something out of it. I hope the Q&A was really helpful to you. If there's something that I can do for you, please feel free to call my office and I will be happy to do it. You know, some people say, waiters say they take tips. I take deals. So if you have deals that I can do for you, I'm more than happy to do that. But I'm even available for you to reach out if I'm not, so I can be a resource to you. And I want to thank Paul and the Association of Realtors for allowing us to teach the class. I think it's really helpful, and I think they do a great job. Carolina will get you a copy of the PowerPoint presentation as soon as possible, probably later today or tomorrow, if I had to guess, but I don't want to put words in her mouth. And with that, Paul, anything that you need to say or take care of?
Just a reminder, on Thursday, we have our marketplace with Pompano Beach Mayor Rex Harden. And then on the 16th, we have the class I put in the chat. And as always, you will get the content of this as I mentioned several times in the chat. And thanks again for attending, and stay safe. Stay safe over the weekend as well when you're going out, or if you're going out on the weekdays. Thanks again for attending. And like I said, you'll be getting this soon. I have to edit it and everything, but you'll get it. If you registered for this, which you obviously did and you're attending, then we have your email. So we'll make sure and get it to you. Thanks again. Thanks, Russ. And I'll work with Carolina to schedule some more.
You got it.
Thanks, Russ. Bye.
All right, take care, guys.